Good afternoon, everyone. I am Sanya Sana from BBA 6M Batch 1, and today I am going to present a detailed overview on the topic Contract of Indemnity, a very important concept under business law. Now we know the topic. Let's begin by understanding the meaning and definition of Contract of Indemnity. So, firstly, what do you mean by the term indemnity? The term indemnity is derived from the Latin word indemnis, which denotes uninjured or suffering no damage or no loss. It is a sort of security or protection against loss. The term contract of indemnity is legally defined in Section 124 of Indian Contract Act 1872. A contract of indemnity is a special type of contract where one party promises to save the other party from the losses. The losses can either be due to the promisor themselves or by the actions of the third party. Let me simplify this with an example. Suppose I take a car insurance policy, and if my car damaged in an accident, the insurance company will pay for the repairs. Here, the insurance company is the indemnifier, and I am the indemnified. And the insurance company is promising to compensate me for the losses. And this is the contract of indemnity. So, in short, this contract protects the person by potential losses and ensures that they can be reimbursed for any financial damage. Now that we know the meaning and definition of contract of indemnity, let us know the key players in the contract of indemnity. A contract of indemnity involves two key parties. First one is indemnifier and second one is indemnified. The indemnifier is the person or the company who makes the promise to compensate for the losses. For example, in an insurance contract, the insurance company will be the indemnifier. And second one is indemnified. The indemnified is the person who is benefited from the contract and is entitled to receive the compensation. In our insurance example, the person who buys the policy is the indemnified. Now that we know who the key players are in this type of contract, let us know the essentials of the contract of indemnity. There are for the contract of indemnity to be essential and for the contract of indemnity to be and enforceable, it must have the following essential element. First one is two parties. There should be in this type of contract there should be involved indemnifier and an indemnified. One party must agree to protect the other and the other must agree to receive it. Second one is lawful consideration. This involves something of value to be received by the indemnifier. This means that there should be any consideration or benefit involved. For example, when we buy the insurance premium, we are offering something of value to the indemnifier. Third one is free consent. This means that both the parties willingly enters into the contract. It should not be forced or made under pressure. And fourth one is lawful object and enforceability. This means that the contract should not be created for any illegal purposes. It must be follow the rule laid down under the Indian Contract Act 1872. Now that we know the essentials of the contract of indemnity, let us know the rights of indemnity holder, the person who is protected under this act, that is the indemnity holder or indemnified. They have certain legal rights. First one is recover damage. Indemnity holder claims all the damages paid in lawsuits. If the indemnified person is sued and ends up paying the damages, they can recover that amount from the indemnifier. Second one is recover legal cost. Sometimes just defending a case in a court can be expensive. The indemnity holder has the right to claim those expenses too, even if they win or lose the case. And third one is recovered payments. This means that if the indemnified person settles the dispute outside the court, and if by paying more money as a compromise, they can ask for that amount from the indemnifier, providing that settlement was done in a good faith. Now that we know the rights of the indemnified, indemnity holder, let us know the duties of the indemnifier who provides the protection to the indemnified. So the first duty is compensation for loss. The indemnifier must fulfill the promise, fulfill the promise and pay for the losses as mentioned exactly in the contract. They cannot back out once the loss occurs. Second one is defend legal action. In some cases, the indemnifier is also required to step in and help the indemnified person during the legal matters, like hiring the lawyer in a court and or appearing in a court if stated in that contract. Third one is act in good faith. The indemnifier must act honestly and try not to cheat or escape liability. Fourth one is respect contractual limits. This means that the indemnifier is only responsible for the losses mentioned in the contract, not for anything beyond that. They are not responsible for any extra losses unless specifically mentioned in the contract. Now, to conclude the presentation, a contract of indemnity is a very useful legal arrangement that provides financial protection against possible losses. It is mostly seen in areas like insurance, banking, and business laws, where the risks are involved. It helps to reduce the financial uncertainty, and this type of contract ensures that the affected party gets the compensation. And most importantly, it is recognized and it is legally recognized and enforceable under Section 124 in Indian Contract Act 1872. That's all about today. Thank you.